Today, we explore a groundbreaking case of Lamplegh v. Brathwait from 1615. In this case, the defendant, Brathwait, had unlawfully killed a man and was later convicted and sentenced to death. In desperation, he asked the claimant, Lampleigh, to travel to the king and obtain a royal pardon on his behalf. Lampleigh undertook the task at his own expense and considerable effort, successfully securing the pardon. Afterward, Brathwait promised to pay him £100 for his services but failed to do so. Lampleigh then sued to enforce the promise. The central issue before the court was whether Brathwait's promise was legally binding, given that Lampleigh's actions had already been completed before the promise was made. Ordinarily, past consideration is not valid consideration in contract law. However, the court held that Lampleigh's act was performed at Brathwait's request, and there was an implied understanding from the outset that payment would be made. Therefore, the later promise merely fixed the amount of an obligation that already existed. The court ruled in favor of Lampleigh, finding the promise enforceable. The legal principle established is that past consideration can be valid where the act was done at the promisor's request, with an implied expectation of payment, and the later promise reflects that original understanding. This case created the doctrine of implied outset. This principle allows a court to infer a promise to pay for services or goods based on the conduct and circumstances of the parties, even if no formal agreement existed at the outset. Now that you know the significance of intention in contracts, think about your agreements. Are you making sure they have legal weight? To learn more about contract law and its applications, subscribe to our channel today.